Hello and welcome to the Scholar Circle, scholarcircle.org. I'm Maria Armoudian. In this hour, what do the Supreme Court decisions in 2020 mean for the future of American politics and society? What is the future of the court, particularly with the potential retirement of Ruth Bader Ginsburg and the 2020 election? How might these influence the other branches of government? Doug Becker explores.
I'm Doug Becker. Since the 2016 election, the U.S. Supreme Court has become a lightning rod political issue on both sides of the political divide. The Trump administration has named 2 new associate justices, and many court watchers expect the court to shift to the right politically and judicially. This term has been presented as one of the most consequential, with the number of high-profile cases decided. But has it shifted rightward as predicted? And what is likely to come in the near future? On today's show, we will discuss the 2020 Supreme Court decisions and what they mean for American politics. Our guests are Sanford Levinson, the W. St. John Garwood Jr. Centennial Chair in Law at the University of Texas. He is author of numerous books, including Democracy and Dysfunction with Jack Balkin and Fault Lines in the Constitution with Cynthia Levinson, the latter coming out in graphic novel form in September. Erwin Chemerinsky, Dean and Jesse H. Chopard Distinguished Professor of Law at the University of California, Berkeley. He is author of numerous books, including We the People, a progressive reading of the Constitution for the 21st century. And Alison Dundes Renteln, Professor of Political Science, Anthropology, Public Policy, and Law at the University of Southern California. She is the author of Global Bioethics and Human Rights with Wanda Tays. Professor Levinson, let's start with you. It seems like the Chief Justice has played a pretty substantial role in this term, the so-called swing vote, and a rather remarkable number of opinions written and seemingly with the majority in every single case. How much of this is John Roberts' court, and what does that mean?
Well, first of all, he actually dissented in 2 important cases, though it is important that he wrote the opinions in a number of very high-profile cases. There are 3 things I'd want to say quickly with regard to your question. First of all, I think that there's no doubt that Roberts, both temperamentally and because he's Chief Justice, is particularly interested in preserving the institutional status of the court. And whether or not you believe that judges follow the election returns, I think he is fully aware that we're deeply, deeply polarized. Even the Supreme Court has only a modest majority of Americans who have confidence in the court, who approve of the court. And so I think he's got a finger held up in terms of what is feasible institutionally and what would be a mistake. Secondly, I think that he continues to be a very conservative man. I think that he and Elena Kagan are the 2 judges on the court who can be said to have a long game. And so I'm disinclined to give any great awards to Roberts for moving left, because I think he expects to be around for another 10 or 15 years and is waiting for the election the way the rest of us are. The last thing I would say, there's a very, very interesting article in Slate earlier this week saying that the real swing justice is Neil Gorsuch, not because he has left-wing views that we were unfamiliar with before, but because he, like Clarence Thomas, and unlike John Roberts, may be more of a true methodological ideologue than any of the other justices. He really does take text and history seriously in a way that Roberts doesn't. And so Gorsuch ended up writing two of the major opinions in the last couple of weeks, where he was assigned the opinion by Ruth Bader Ginsburg because John Roberts was in dissent. And I found this Slate column really, really interesting. And it does at least invite a larger discussion of what we mean by a swing justice.
And Professor Chemerinsky, your thoughts?
I think we truly saw this term that it is the John Roberts court. Roberts was in the majority in 97% of all the cases. As Sandy said, Roberts dissented twice in Ramos versus Louisiana and McGirt versus Oklahoma. But I think it's notable that out of 53 cases, he dissented only twice. In terms of the swing justice, you might think of it in political science terms of who's the median justice ideologically. I think that's John Roberts. You might think of it more practically. Who's the justice most likely to cast the deciding vote? That's John Roberts. Think, for example, of the Daca case. Think of the abortion case. I don't know that Roberts moved left, but it is hard for me to reconcile his vote in the abortion case, June Medical Center versus Russo, with having dissented just 4 years ago in Whole Women's Health versus Hellerstedt. It's hard for me to reconcile his being in the majority in Bostock, and therefore he was the one who assigned that opinion to Gorsuch, when just 5 years ago in Oberfeld versus Hodges, he dissented with regard to marriage equality. So I do think that John Roberts is the swing justice. Agree with Sandy very much that I think Roberts has a long game. I think we can trace some of what he did this term to what he had done previously. I think that one place where Roberts is very conservative and pushing the court in a conservative direction is with regard to the religion cases this term. I think the court moved substantially to the right with regard to protecting free exercise and lessening the wall that separates church and state. In terms of Neil Gorsuch, there are instances where he will be the swing justice. He wrote the opinion in Bostock, the case that said that Title VII prohibits employment discrimination based on sexual orientation and gender identity. He wrote the opinion in McGirt, the case with regard to Native American rights in Oklahoma. I agree with Sandy that I think that he is much more ideological and much more ideologically pure than anyone on the court other than Clarence Thomas. And so sometimes you'll get some strange results like those. But let there be no doubt, overall, Neil Gorsuch is going to vote with the conservatives far more often than not. And so is John Roberts.
Yeah, I agree.
Professor Renteln, your thoughts?
I agree with my distinguished colleagues, but I guess I want to acknowledge that justices are aware of their role in history and that they do sometimes defy expectations. So Justice Gorsuch, I think, has a kind of libertarian view of certain issues. And when I heard him speak at Oxford about a year ago, I found him very thoughtful. And so I think, there are conservatives, but there are different kinds of conservatives. And so I think it's worth paying attention to their views, especially when the stakes are so high. I mean, we're in this pandemic. The country is so polarized. And there are sort of famous examples through history. McCloskey Levinson book on the Supreme Court, traces some of these. But, justices don't always vote the way we expect. Professor Chemerinsky is, a brilliant analyst of the court, and I'm sure he's right in his predictions, but there are these moments when they defy expectation. Another thing I think that's interesting is we have so many Catholics on the court. And so I wanted to say that Professor Chemerinsky's remarks about the view of religion, I think, does give us pause. I mean, even in the Bostock case, Gorsuch emphasized that the cases didn't present the question of the tension between the Religious Freedom Restoration Act, RFRA, and Title VII. And so we don't know if his treatment of civil rights, will, even for him, will, continue when there's a question of religious freedom that is presented in the case. I do think it's an amazing moment that we have so many Catholics and Jewish justices. And so I wonder what my colleagues think about what role that may play in terms of their approach to some of these cases, which, that's an issue besides their judicial philosophy.
One way of answering that question is that To discuss that overtly is to threaten to touch a kind of third rail, so that Scalia was extraordinarily angry when people said his Catholicism was relevant. On the other hand, in Obergefell, he kind of broke frame, as it were, by pointing out altogether accurately that there are not only are there no Protestants, or there were at that point. Neil Gorsuch technically is a Protestant because he converted from Catholicism to Episcopalianism. Obergefell was 6 Catholics and 3 Jews. Scalia pointed out not only there were no Protestants, but no evangelicals. And the only way you could read that is to suggest that were there an evangelical on the court, that might have been significant. I actually believe that this is a discussion very much worth having. The only school I'm familiar with that's actually been willing to touch this is St. Thomas I think they're in Minneapolis rather than St. Paul. I attended a wonderful conference there where there were really serious discussions of Catholic theology, notions of complicity and the like. And they were kind of insulated because they're a seriously religious school. I think that if you look at secular schools, secular law reviews, there's just a huge tendency not to want to talk about this. When Dianne Feinstein, for example, quite clumsily, I will say, but altogether accurately asked Amy Barrett, who's a very serious conservative Catholic, how she might link that with most obviously abortion, she was castigated and saying, separation of church and state means that you never can ask a nominee about his or her religious views. I disagree with that, but I know from experience that I'm in a minority of people who think that on occasion it is perfectly appropriate to ask a nominee who has said, I always ask, what would Jesus do? Well, how do you know what Jesus would do? And under what circumstances would Jesus take priority over, what you think the Constitution might unwisely require?
Professor Chemerinsky, you had referenced this question about church and state, and Professor Levinson raised this question about church and state explicitly with respect to justices. Do you think that's a fair question to ask of nominees, and also a fair question for academics to raise when analyzing outcomes of certain cases?
I think it's completely appropriate to ask a nominee what his or her views are on the issues. Throughout American history, presidents have chosen nominees based on the views of the issues, and I think it's appropriate for senators to ask about the views of the issues. That's not the same as asking, how will you vote in a specific case? That, of course, will depend on the facts of that case and the briefing of that case. But the reality is how justices are going to vote is very much a product of their views. And I think it's completely appropriate then to ask about those views. In terms of Amy Coney Barrett, she had written a law review article where she talked about her Catholic theology and how it should affect one's views on constitutional issues. That's what made it, in that instance, completely appropriate to be asking her. But I also agree with Sandy that Senator Dianne Feinstein's questions were clumsy and led to a lot of criticism of her, which I think will make others reluctant to do it. I mean, I think that at least 2 of the religion cases decided last couple of weeks by the Supreme Court are going to have enormous implications. One of them is Espinoza versus Montana Department of Revenue. Montana adopted a law that created a tax credit program for parents who sent their children to private school, secular or religious. The Montana Supreme Court struck it down as violating the Montana Constitution, a provision in the Constitution that said there couldn't be direct or indirect state aid to religion. I would have thought that would have ended the matter. There is no Montana law. It's not favoring anybody or anybody else. But the Supreme Court 5-4 said that to strike down the Montana law itself violated free exercise of religion. The only way I could read Chief Justice Roberts' opinion is it now means anytime the government is giving a benefit to a private secular school, it has to give that benefit to a private religious school. It mandates, from a constitutional perspective, government aid to religion. And briefly, the other case I'd mention is Our Lady of Guadalupe School versus Morrissey Baru. There, the Supreme Court held that religious schools are completely exempt from employment discrimination law with regard to their teachers, that a teacher can be fired, as in these two cases, for age or disability, or be fired on the basis of race or sex, religion, sexual orientation, with impunity. To me, this is a tremendous extension of protection of religious institutions to inflict harm on others.
You're listening to Scholar Circle, scholarcircle.org. I'm Doug Becker, and our discussion today is on the recent term for the U.S. Supreme Court, the direction the court seems to be heading, and some thoughts about the potential for certain future cases. And Professor Renteln, another case I know in dealing with this question of church and state was the so-called the Little Sisters of the Poor case, with the right of employers to deny women access to contraception as parts of their health care plans. Is this consistent with some of the other cases, and are we seeing really a kind of a reinforcement of what's being described as religious liberty as the right to discriminate or the right to make decisions based on your stated religious beliefs?
I'm not sure how to respond to that, but I think what strikes me about that debate is the sort of trend towards narrowing abortion rights in the U.S. as compared to other countries, where even in Catholic countries, Ireland and Chile and so on, that finally there's been an expansion of abortion rights in other parts of the world. So I think putting that sort of issue in a kind of comparative perspective shows that having a particular religion as dominant doesn't necessarily require a denial of abortion rights.
Professor Levinson?
I think I would offer as a caveat that it's no longer clear what it means to describe, say, Ireland or Spain as Catholic countries, or even Italy for that matter, because I think for a variety of reasons, there have been profound cultural shifts, and the church in all three of those countries has lost enormous both power and cultural prestige. The remarkable thing about the United States is that among all of the so-called Western countries, I think it's fair to say that it's the most religious in terms of the numbers of people who will say they're religious believers. The number of agnostics and atheists is rising, but it's still really remarkable in many ways how many Americans continue to be believers, will attend religious services, and take religious figures really very seriously. So, I think that's just part of the cultural reality of where we are, for better, and I would often say for worse.
Professor Chemerinsky, this kind of raises an interesting question for me about the role that religion plays in law, because there's sort of a, I guess for lack of a better framing, a positive versus negative approach in that, does your religion highlight the positions that you take in jurisprudence versus this interpretation that the protection of religious freedoms actually lead to judicial outcomes that might deny access to services? There seems to be, two fundamental questions. Does religion highlight your, certain outcomes, or is it framed as, we call it religious freedom, but it's actually the religious freedom to discriminate?
Let me break that down into two parts. First, how justices decide cases or how judges decide cases. The reality is that, especially at the level of the Supreme Court, it's often true at appellate courts, there's a tremendous amount of discretion. And who the judge is, what the judge believes, will often influence how that discretion is used. There's a reason why Clarence Thomas and Ruth Bader Ginsburg rarely agree. It's because they have different ideologies. First question that I have when I'm arguing a case in a court of appeals or know somebody who's arguing is, who's the panel? Because I know in certain kinds of cases, the identity of the judges matters so much, and religion is part of the background that the judge brings, along with many other things. In terms of the second aspect of your question, my view is that the Establishment Clause of the First Amendment was, in the words of Thomas Jefferson, meant to create a wall separating church and state, and that free exercise of religion should not include the ability to inflict injury on others. I actually think Justice Scalia got it right 30 years ago in Employment Division versus Smith when he said that religion shouldn't be a basis for an exception to a general law. And I think the problem with the Supreme Court did this term is it allows people in the name of religion, religious schools, to discriminate against teachers based on race, sex, religion, sexual orientation, age, disability. I think the problem with the contraceptive mandate case, Little Sisters of the Poor, though it wasn't a constitutional case, was it still allows religious institutions to inflict injury on people in the name of religion, denying contraceptive coverage for women. And I don't think that free exercise of religion should be a basis for people being able to inflict harm on others in the ways that we're talking about.
Professor Levinson?
I am in broad agreement with Erwin about the diciness, for lack of a better word, of certain accommodations. I think each one would have to be discussed separately, but I share his view that the exemption from, say, the Americans with Disabilities Act is really unsustainable. I suspect where Erwin and I might disagree is the issue of benefits, because William Rehnquist wrote a dissenting opinion now 35 years ago or so, where he said that there's a fatal tension between the Establishment Clause and not the Free Exercise Clause, but the Equal Protection Clause, that in 1787, nobody knew about a welfare state. The state didn't tax very much, and so it was really glaring when Virginia wanted to tax people so they could pay for ministers. No, they can't do that, period. What happens when you have the modern welfare state, where the state is in fact a tax and spend state, which I think Erwin and I both support as liberal Democrats. And so you find, the state, whether it's California, the national government, giving out huge amounts of disaster relief and the like. So at that point, do you want to say, well, your local bookstore, grocery store, fill in the blank, will be entitled to state aid, but if you're a religious school, no. Michael McConnell, who's now at Stanford, had been a judge on the 10th Circuit, and my former colleague, Doug Laycock, I have to say, have influenced me greatly on this. I think it's kind of a red herring to talk about free exercise. I think the real problem is trying to figure out what in the world equal protection means in the age of the modern welfare tax and spend state. And when it is fair to say, no, you're not going to get the state aid because you're religious. We're not going to pay for your Torah. We're not going to pay for your communion wine. But does that also extend to we're not going to pay to rebuild your church after hurricane? I find this really, really difficult. And frankly, I don't think that what Thomas Jefferson or James Madison or any other 18th century figures had to say is very relevant.
Professor Renteln?
I attended a conference at Harvard Law School with people who were on the equal protection side and people who were on the religious exemption side. And it brought together two groups of scholars who usually don't have a conversation. And so I think what you're saying very, very important. I think it is worth having a more nuanced approach to the different kinds of religious exemptions. We've always had religious exemptions that permit the slaughter of animals, for example, for Muslims and Jews, and at the state level. We've allowed religious exemptions in some countries for people to wear religious symbols like the kirpan. So, and I guess in many states, there are laws against wearing masks that had exceptions for Halloween and for religion and for health reasons. And most of the laws where people want to wear the masks and they weren't allowed to. And now, of course, we have the opposite problem, but that's another point. So I guess I just want to say to Professor Chemerinsky, it seems like having exemptions doesn't always involve doing harm to other people. I think in the civil rights area, we have a different question. And Martha Minow wrote, I think, a brilliant essay about the question of exemptions to civil rights laws, which does not cover disability, but I think could be extended to that. So I think it's more complicated, although I do worry about the direction of the court, as you mentioned. Professor
Chemerinsky?
I think Sandy is right in posing this profound question. I think Alison is right in pointing to implications of it. I think that the question, though, then becomes, if you phrase it as equal protection, is there a compelling government interest in stopping religious institutions being able to discriminate on the basis of race or sex or religion? Is there a compelling government interest in forcing employers to provide contraceptive coverage to women? And to put it another way, is avoiding violation of the Establishment Clause a compelling interest that justifies treating religions differently under equal protection? And so I'm perhaps a little bit less convinced that whether you call it equal protection or free exercise makes a difference. I think in the end, those are the issues that are going to have to be faced. And my answer would generally be is, yes, there's a compelling interest, whether you call it free exercise or whether you call it equal protection.
So Professor Renteln, you had raised an issue sort of from this comparative perspective on specifically on issues like the abortion case and abortion rights. The United States seems to be going in a very different direction than a number of European democracies on issues on gender equality, on women's rights, on reproductive rights, et cetera. What is it that you think is behind this drive rightward in the US, whereas in a number of countries in Europe, the drive seems to be towards expanding gender equality or reproductive rights?
Oh, that's a really easy question to account for the trend towards a kind of populism that would deny people rights and the kind of hyperpolarization. I think it is striking that the American exceptionalism is so pronounced now. Whether we're talking about the U.S. not being part of the International Criminal Court, withdrawing from the World Health Organization. I think President Trump is responsible for some of these decisions, but I think the American public is very disenchanted with certain kinds of progressive policies. Surely income inequality is part of that. But there's so many areas where the U.S., I think, is sort of an outlier, whether we're talking about American attitudes towards torture, the death penalty, which has been abolished in most parts of the world. So many different issues. But I guess the one that seems to really stand out for me is the status of women's rights, and that despite the Me Too movement, women's rights have still not really reached levels of protection that we would hope for. And I'm thinking of one particular illustration, which is in most Western democracies, when countries have evolved, they've changed the images on their money, the iconography of their money. And it includes women, it includes natural symbols. And our colleague Jacques Hymans at USC has written a wonderful scholarship on this. But Harriet Tubman was supposed to be added to American money. So we're like the only country where they couldn't manage to get the image of a woman on a bill, just as a sort of illustration. My husband says it doesn't really matter because everyone's using plastic now anyway. They're only talking about putting women on bills now when people aren't using money.
Professor Levinson, you had indicated some of this difference is because the U.S. population tends to be more religious than European counterparts. I think implicit in that is the idea that the courts are reflecting public attitudes, public opinion, perhaps more so than at least the court gets presented as an ideal of interpreting the law as opposed to just simply reflecting public opinion. What exactly is the relationship between the two?
Yeah, we could spend obviously the rest of our time on how one teases out that relationship. I think on abortion, it's hard not to come back to how we began this program, which is the relevance of the fact that 5 members of the court are either conservative Catholics or, as in the case of Gorsuch, a convert to Episcopalianism from Catholicism, who in fact was educated in Catholic schools and wrote an Oxford PhD, I think, on the particular problem, if I recall, of assisted suicide or euthanasia. Justice Sotomayor is also Catholic, but I don't mean to be libeling her in saying that I think she is less of a right-wing Catholic. I don't want to say serious Catholic, but less of a conservative Catholic than the others. If you look at some of the decisions on the circuit courts, the Trump administration has been stunningly successful in packing the circuit courts with conservatives. And they're often Catholic. Amy Barrett is a wonderful example of this. I've never met her. By all reports, she's both very smart and very pleasant and very conservative Catholic. Ironically enough, it might be that Roberts was in fact paying attention to public opinion because most Americans, in fact, support the rather clumsy set of compromises the Supreme Court has ended up with on abortion. It's simply not true that a majority of Americans are anywhere close to supporting the overruling of Roe versus Wade. That's a minority position, but it tends to be found among conservative Catholics and evangelical Christians. One other factor, again, going full circle to John Roberts, my own view is that Roberts, for a variety of reasons, doesn't really want to overrule Roe, but he wants to strangle Roe in the crib. And so what he will do is find almost anything not to be an undue burden. And I think that the best explanation for the Louisiana case is that the Fifth Circuit was behaving as a rogue court in upholding something that was clearly unconstitutional under this 4-year-old case in which Roberts had dissented. And I think there it's a combination of his institutionalism. You're just not going to diss the Supreme Court that way. And the fact, and here's where, I don't know if Erwin would agree or Professor Ryan would agree, that he is a committed Republican who believes, I think correctly, that it is not in the interest of the Republican Party to overrule Roe versus Wade. And because at that point, Republicans would really have to take full ownership of the abortion issue, which they haven't done now for 50 years. They've been able to blame the court for the clumsy compromise that most Americans agree with. I don't think one can avoid looking at the religious views that contribute to the worldview of the 5 members that we usually refer to as the majority of the Supreme Court.
Mr. Chemerinsky, your response?
John Roberts came on the Supreme Court in October of 2005. From then until the decision just a couple of weeks ago in June Medical Center versus Russo, he had never voted to strike down any restriction on abortion. Mm-hmm. As Sandy rightly says, he dissented along with Justice Alito and Thomas in Whole Woman's Health versus Hellerstedt. So the question is, what do we make of his being the fifth vote to strike down the Louisiana law? I think Sandy's explanation makes great sense, that the Fifth Circuit was so blatantly disregarding a recent Supreme Court precedent that he was standing up for the institution of the court. He relied on stare decisis. There are plenty of cases in the last few years where the Supreme Court has explicitly overruled precedent, with John Roberts in the majority. I argued one of them a year ago, Franchise Tax Board versus Hyatt, lost 5-4, or quite importantly, 2 years ago, Janus versus American Federation, overruling a 40-year-old precedent quite crucial for labor, John Roberts in the majority. Why, if he didn't care about stare decisis in those cases, here? Maybe Sandy's explanation is right, that Roberts won't be the fifth vote to overrule Roe. He'll just allow the states to adopt laws that effectively overrule Roe, this targeted restriction of abortion providers. Maybe when the issue of overruling Roe and Casey is squarely before him, his anti-abortion views will triumph, and if he's got 5 votes, he'll be part of that majority. Maybe it's an enlightened, what's in the best interest of the Republican Party, that it would be bad for Republicans to overrule Roe, so he won't vote to overrule Roe for that reason. But I just regard it as an open question at this point. When the issue is before the court is whether to overrule Roe or Casey, where will John Roberts be? I don't think we can know, and I don't think June Medical Center tells us the answer to that question.
I agree with you completely. And it may very well turn on the results of the election. And to what degree Roberts, as the Chief Justice and the presumptive swing vote, will be willing to really draw this line in the sand, instead of just continuing to say we don't need to reach the question because this doesn't count as an undue burden.
Isn't this what Rick Hassan calls stealth overruling, where they keep trying to whittle away at the precedent? This is one of the only powers that women have that men don't have, which is to give birth. So maybe this is something women should decide, and that if we lose abortion rights in the court, which, depending on the health of Justice Ginsburg, could happen, we'll have to get a statute in Congress, so more women will have to get into Congress, or we'll have to have more justices appointed to the court. It seems like this should be an issue that women should have more say-so. It always bothers me that it's something that male legislators and male judges think they should decide for us.
This, incidentally, is why my greatest fear in literally the next 4 months is that Amy Barrett will succeed Ruth Ginsburg, because she provides a certain sort of response to the argument you just made that I agree with completely. But she is, I think it's fair to say, rabidly anti-abortion, and wouldn't hesitate, for a second in overruling that. So that would turn out to be a 6-3 decision, and Roberts would be off the hook.
Yeah. Well, I don't mean to suggest that all women are pro-choice, certainly, but I think that if women were the majority in Congress, we might be having a different conversation about this.
I agree with you completely. I'm not a big fan of Roberts. In my most cynical moments, I view him as kind of a mouthpiece for the capitalist empire. That is a judge who really wants to preserve the power of big business, which means, among other things, to be anti-regulation and to want to bust unions. One used to speak of country club Republicans, and I think country club Republicans were pro-business, anti-union, and often socially liberal in some ways. George H.W. Bush used to be a strong supporter of Planned Parenthood and to support abortion before his political interests required what he thought was a switch. I have no idea how strongly John Roberts really and truly is opposed to abortion. I am certain that he has never seen a labor union or a member of a labor union for whom he has any sympathy. He is one of the forces behind the most truly wicked decisions of his court, which are the arbitration decisions that have cut off access to courts by most ordinary Americans who are faced with individual corporate misconduct. And that, I think, is where his real heart and soul as a longtime Washington lawyer is. I don't think big business cares one way or the other about capital punishment. Actually, I don't think they care about Obamacare, because it's kind of crazy to have medical care financed by industry instead of by the state. I don't think they care about, sexual orientation. If anything, they are on the progressive side on that issue. What they really care about is the bottom line. And there, I think Roberts is loyal an ally as they can find.
Professor Chemerinsky?
I think above all, John Roberts is a pro-business Chief Justice. But I also think that in race, you can't forget his opinion, and parents involved in community schools very strongly opposed to affirmative action. Notwithstanding his being in the majority in Bostock, he dissented in Obergefell. I predicted wrong. I thought he was going to be in the majority to say that laws that prohibit same-sex marriage are unconstitutional, because he cares so much about his legacy. I thought he'd want to be on the right side of history. Not only did he dissent there, but the only dissent he's ever read from the bench was with regard to Obergefell. So I agree with your characterization, but I also think that these things put him much more squarely in the mainstream of the Republican Party.
I agree with that. I also think the decision in Shelby County, voting rights, is disastrous and indefensible. I think he has never met a voting restriction, all of which are, at least by popular assessment, designed to help the Republican Party. I don't think he's ever met one that he hasn't accepted. So some of that might be because of his views on race, which Erwin is adverting to. Some of it might be because he simply wants to see the Republican Party victorious. So that, just a couple of days ago, the Supreme Court has acquiesced in the probable disenfranchisement just 14 or 15 weeks from now of thousands upon thousands of freed felons, former felons in Florida, because they refused to lift the stay on a perfectly correct district court decision.
Now, this creates a model of governance where, as Professor Renteln pointed out, perhaps the answer to a number of these more conservative rulings is more progressive legislatures that are passing laws that are meant to try to address these concerns. But the three of you are certainly painting a picture of a court that's prepared to step in, perhaps overturning some of the cases, arbitration or on unions, the willingness to overturn certain legislation. So we have a court that seems to be much more conservative than, even if we have progressive legislatures elected. And so historically, this really hasn't happened since the 1930s. Mm-hmm. What does this mean for American politics if you have a court that's considerably more conservative than the legislature? I'll ask Professor Renteln this question first.
I think that it would be good for us to talk about some kinds of responses, like the attempt to pack the court, whether having courts that have more justices and therefore more points of view would kind of dilutes the effect of someone who seems to block progressive interpretations of rights and so forth. Also, the issue of term limits that I believe Professor Chemerinsky has championed the discussion of that, and having rotating times when people are picked and so on. I think that social movements also play a role. So it's not just the interplay of the different branches of government, but we have to look at the role of social movements. And we don't have time to get into the impact of public opinion on the court, but I do think that sometimes justices defy expectations in history, and that we can hope that some justices will reflect on their legacy. And even if they haven't done so up to date, that could be ahead, I hope.
You're listening to Scholar Circle, scholarcircle.org. I'm Doug Becker, And our discussion today is on the recent term for the U.S. Supreme Court, the direction the court seems to be heading, and some thoughts about the potential for certain future cases. Professor Chemerinsky, since Professor Renteln had highlighted questions about whether it's increasing the number of justices or changing the way we choose justices, this of course came up during the primary season. I remember Pete Buttigieg had raised the issue initially about increasing the size of the Supreme Court, and it was kind of dismissed out of hand. Is this something that's possible? And if so, what do you propose would be the best way to try to address this concern?
The size of the Supreme Court is set by statute. It's not fixed by the Constitution. I think at this point, I would say it's unlikely that even if there's a Democratic president, a Democratic Congress, that they'd push through expanding the size of the court. Maybe that's because court packing still has such negative connotation in the 1930s. But to tie this to an earlier part of the conversation, I will make a prediction, and it's a bold one. If, God forbid, something happens to Justice Ginsburg between now and January 3rd, and Amy Coney Barrett is nominated by President Trump and confirmed by the Senate, I think that combined with what happened with regard to Chief Judge Merrick Garland, court packing will then happen. That I think then there will be a bill passed to increase the size of the Supreme Court from 9 to 11 because of just the blatant hypocrisy of Republicans saying in 2016, a president who's lame duck, or at least in an election year, shouldn't fill a vacancy, in this term do so. I would like to see 18-year non-renewable terms for Supreme Court justices. I think it would take a constitutional amendment. I don't think it's going to happen. I think the proposal that some made for rotating Supreme Court justices is a terrible idea, and I hope it never happens. I look at who the Court of Appeals judges are. I wouldn't want them randomly being chosen for the Supreme Court.
We probably don't have time to get into a discussion of this very last point. Should the Amy Barrett scenario happen, the only disagreement I have with Erwin is on the number. I think that the court would have to be increased to 13 because if it's simply 11, that still leaves 6 conservative judges in control.
Great point.
But otherwise, he's spot on.
It's an unlucky number.
Yeah, so go to 15.
Maybe state Supreme Courts will start to play more of a role. We haven't talked about state constitutional law, but I think we're going to have to think imaginatively about how to protect rights and the interpretation of the Constitution that we seem to share, because it is a pretty pessimistic view. And even though I keep being, hopeful that the justices will see the light, I have to agree with my colleagues. I'm worried too.
One other issue that certainly manifested itself recently has been the way in which the executives, whether it's the state executives like in Florida with the felon voter case and the state proposition that had empowered them, as well as the Trump administration's seeming refusal to process new applications for Daca, regardless of what the court had said about the constitutionality or the legality of Daca, raises the question whether the court is potentially losing some of its power because executives are just not acting on decisions, or will the court step in and try to compel executives to actually do what they've been ordered to do or empowered to do? Is this a concern, or is this something that's being kind of blown up? Professor Chemerinsky.
I think the Roberts Court cares very much about the power and prestige of the Supreme Court. I think if the Trump administration openly defies the decision in Daca, I think the Supreme Court will say, you have to obey our decision and issue orders to make sure that it happens. I'm persuaded by Sandy's explanation earlier that one reason why Roberts went along with the majority in striking down the Louisiana abortion law was because of the open defiance of the decision by the Fifth Circuit. I don't think that Roberts is going to accept open defiance by the Trump administration to the Daca ruling.
I also think with regard to the Daca ruling, it's important to note that he got everybody but Sotomayor behind the view that the real problem was that they hadn't dotted the I's and crossed the T's, that it's a technical administrative law decision so that if, God forbid, they're reelected and they repeat their desire to do in Daca in a more technically proficient way, then I think you've got 5 votes to say you can do that. I don't know whether he is really and truly somebody who takes legal technicalities very seriously. I mean, this was the basis also of the census decision last year that surprised a lot of people, or whether he's very, very cagey, recognizing that the Trump administration is disastrously incompetent and picks fights that are not, in fact, politically popular. Some of them are. And so he really paid no cost in holding their feet to the fire and saying, we're not saying you can't do this as a constitutional matter. Rather, you're going to have to dot the I's and cross the T's, and you kick the can down the road. He's very good at that when he wants to.
Considering the passions that the country certainly seem to be raised on court issues, ranging from the emotions of the Brett Kavanaugh confirmation hearings and, of course, the decision to not consider Merrick Garland, as well as a pretty regular reporting on the health of Ruth Bader Ginsburg. It's become axiomatic to say that conservatives vote based on the courts, liberals don't really seem to care. Do you think this is going to change, and that in particular with the election coming up, that the court is going to play a pretty substantial role in, say, more liberal voter turnout? I'll ask Professor Renteln that first. I'll allow all three of you to respond.
Well, I hope that people are paying attention because there is so much at stake in terms of the issues that we've been talking about. Justice Ginsburg has been the subject of two movies, RBG and On the Basis of Sex, which are fantastic. And so I think public awareness of the court, we hope, is higher. I don't know if listening to the court on the radio and having some virtual courts, I hope that maybe people are paying more attention, but I don't know if that's the case. I'm curious what my colleagues have to say.
I think we really don't know. I mean, Donald Trump's most single brilliant move in 2016 was releasing the list. And whatever else you think of Donald Trump, whom I despise, he kept his promise on the list. He gave the constituency that voted for him because they wanted conservative judges. He came through for them in a way, quite frankly, that Barack Obama did not come through for us. So I think it's an interesting question. Will Joe Biden choose to make this an issue? And how do you make it an issue without publishing his own list? I have no idea what he's going to say, but if he doesn't publish a list, then I would think that the Republicans will be passionate and Democrats will tend to focus on other things.
The premise of your question is right. According to exit polls, the number one reason that Trump voters gave in 2016 for voting for him was the Supreme Court. 54% of Republican voters said that the court was why they voted for Trump is the number one reason. But if you ask Democratic voters why they voted for Hillary Clinton, it was number 4 on the list. That said, I don't know that the court's going to be a particularly salient issue for Democrats this time around. Some of it is this election in itself isn't likely to determine the swing justice for the future of the court in the same way that the 2016 election would, at least in the short term, because then there was the sense that whoever replaced, say, Anthony Kennedy was going to determine the future of the court. Well, we've already seen that happen. We've seen it happen with regard to filling the Scalia vacancy. So there's less of a sense that this election is going to immediately shift the outcome of what goes on in the Supreme Court. I think that's short-sighted. I think in the long term, since it just lasts a long time, it has an enormous effect. Also, there are so many reasons why Democrats are going to oppose Donald Trump. Harder to say that the Supreme Court is going to be high on the list. I agree very much with what Sandy said, that what Donald Trump did by releasing his list of prospective nominees in 2016 was give a reason for evangelicals who would otherwise oppose him to come out for his support. Joe Biden releasing his list, I don't think is going to influence a group to come out and support him that otherwise wouldn't. So there to me is the difference. But I've always wished that Democratic presidents would take the courts as seriously as Republicans do.
And with that, I want to thank our panel, Professor Levinson, Professor Chemerinsky, Professor Renteln. Thank you for an extremely enlightening conversation about this term on the Supreme Court and the court's future.
Thank you.
Our guests were Sanford Levinson and W. St. John Garwood Jr., Centennial Chair in Law at the University of Texas. He is author of Democracy and Dysfunction with Jack Balkin. Erwin Chemerinsky. He is the Dean and Jesse H. Choper Distinguished Professor of Law at the University of California, Berkeley. He is author of We the People, a progressive reading of the Constitution for the 21st century. And Alison Dundes Renteln, Professor of Political Science, Anthropology, Public Policy, and Law at the University of Southern California. She is author of Global Bioethics and Human Rights.
Thank you to our guests and to you for listening. The Scholars Circle team includes Doug Becker and Lillian Ng, contributing hosts, Ankine Agassian and Melissa Chiprin, managing producers, Sud Dongre, our webmaster, Tim Page and Mike Hurst, engineers and technical support. I'm Maria Armoudian, and we'll see you next week.